The idea of academic freedom, the idea of being the critic and conscience of society as part of your academic freedom, it's actually not just a good thing, it's a legal right. And it's a legal right because in the Education Act 1989, it's set out as a right that all academics in universities have. If you look into the text of what's in Part 14, you'll see that the object of it, according to Parliament, is to enhance academic freedom. So it says, this is the express language, it is declared to be the intention of Parliament in enacting the provisions of this Act relating to tertiary institutions, that academic freedom is to be preserved and enhanced. And it includes the freedom of academic staff and students to question and test received wisdom, to put forward new ideas, and to state controversial or unpopular opinions, as long as you do it within the law. It's got to be done within the law. So what does that mean? Well, within the law means you can't be defamatory, for example. So defamation, if you express an opinion which doesn't have a decent basis to it, or you express an opinion not in order to progress discussion, but in order to badmouth somebody, and you're doing that deliberately to knock them down, that wouldn't be within the law. So that's not proper academic freedom. Another example, you can't do something which would be a breach of the law on freedom of expression. You can go so far with freedom of expression, but you can't, for example, incite violence. You can't incite hatred of somebody on the basis of their race, their religion, what have you. That's not within the law. But aside from examples like that, as long as what you're doing is lawful, in either the civil law or criminal law sense, it's fine. Section 161 of the Education Act 1989, which is the one that sets out and defines this reference to academic freedom, also has a provision which says that universities, institutions, who in exercising their academic freedom, which as we say they do through their staff, have to do so in a manner that's consistent with the maintenance of the highest ethical standards. So there may be points at which you can say something which you could say is strictly legal in that it's not criminal and it wouldn't lead on to an action against you for defamation, but is not ethical. So what do we mean by ethics in that situation? Well, my suggestion would be that it's consistent with good academic standards. So, for example, if you're expressing an opinion, make sure you've got a research or evidence base for it. If you're saying something that is potentially controversial, have a good logical argument resting on sound premises before you say it, because otherwise you're saying something which might be legal, might be within your freedom of expression rights as a matter of law, but wouldn't be ethical. Do you have to be speaking in an area in which you're an expert? Now, that's something on which people may have different views because it's not entirely clear what the law requires in that. My own view is that if you've got sufficient expertise and you are following the appropriate standards of having a research-based, evidence-based, logical connection basis to your opinions, the fact that you don't teach that area, the fact that you haven't published articles or books in that area, that doesn't stop you having an ethical basis for your statement. So I'd say, yes, you need to have a degree of expertise, but you don't need to be the registered expert in that area to express a view that's ethical.